Hello, my name is Austin Gilly, and my fatherhood is on trial with AI. The next review was 3 months out in 2024. I had not seen my children since September, and I had no way of paying for visits. Days passed, then weeks. The judge had handed the court appointed therapist the keys to my visitation, but her office did not return my calls. The last time she had reached out to me was October 19th. I emailed, I left voicemails. November became December. I wrote 4 Christmas letters, one to each of my children via text. I picked one memory for each: Christmas lights with my middle daughter, the basketball goal to play with my son in 2021, the foosball table my youngest daughter and I had played for hours, the Christmas programs my oldest daughter organized. I ended each letter the same way: I love you no matter what, and I am here for you whenever you want to talk or see me. I do not expect you to respond, and none of them did. In January, out of desperation, I posted a video on my GoFundMe page launch. I built it out of footage my wife had created and was played at the 2023 hearings. Home videos of me playing with the kids, just being dad. I addressed the closing slides directly to my 4 children in case they ever saw them. I needed money. I needed to pay the therapist. I needed someone to help me make this stop. On January 4th, 4 days into the new year, opposing counsel filed a contempt application against me, 3 counts. The first was about bank account transfers from May of 2022, 20 months earlier. The second was that I had stopped paying the therapist in October. The third was that 2 days before that filing, I had told my wife I could not afford to keep paying everything and would be late on support payments. On January 29th, the journal entry from the November 9th hearing was finally filed, almost 3 months after the hearing. On Valentine's Day, I recorded an audio letter for each of my children individually and sent them via text. I read each one my words. I told them I loved them. No one wrote back, but Mom's attorney addressed them in a later filing. On March 7th, I appeared in court for the contempt arraignment. I pleaded not guilty. The court released me on a personal recognizance bond. My attorney asked the judge to suspend alimony until trial and to lift the requirement that all my visits go through the therapist since I could not afford her. The judge denied both requests. The trial was set for August 21, 5.5 months away. A few days later, the therapist's office finally responded. She would resume once I paid off my balance. On March 31st, I sent the kids a group text for Easter. A year of negotiations had gone nowhere. I wrote that their mom and grandmother would not talk to me about anything unless I agreed to give them up completely. I told the kids I could not and would not do that. I told them I loved them. I wrote that if their messages were being screened, the message was also for the screener. Jesus died for you too. On April 4th, opposing counsel filed 3 things at once: an amended application for indirect contempt, adding to the financial counts from January, a second application for indirect contempt, an entirely new track, this one for my text to the kids, the Valentine's recordings, the GoFundMe video, and the Easter message, and a motion for no contact. This was asking the court to stop me from speaking to my children at all. On April 15th, my wife sent me information through the parenting app. My middle daughter would be signing a letter of intent at the technology center. I asked my daughter directly via text if she would be okay with my attending. I had not heard from her in 7 months. She wrote back in 3 minutes. Please do not attend. I am not comfortable with you being there. I thanked her for responding, and she wrote back, confused, asking whether I would be there. I told her I would respect her wishes. She wrote, quote, I am not going to change my mind. Please do not come. 6 messages, 15 minutes. She had spoken to me. Then the silence resumed. On May 1st, near the second anniversary of the day my mother-in-law filed the divorce petition, I sent the kids a letter I had been writing. I told them I had planned to send it on the anniversary itself, but a motion had been filed to prevent me from having any contact with them at all. So I was sending it early, just in case. I mentioned a young woman named Madison who had been alienated from her father for 20 years before finding out what had been done to her. I also recommended a book to my oldest daughter. The same day, I sent the kids a group text. I love you, I miss you, I pray for you every day, and I will plan to continue even if I am blocked from communicating with you directly. If you don't hear from me for a while, please know it is not by my choice. On May 2nd, there was a hearing on the no contact motion. I could not attend because of work, and my attorney could not attend either. The judge took the motion under advisement and ordered an answer on file by May 23rd. On that date, my attorneys filed the objection, writing this was parental alienation, that the children's behavior was the evidence, that opposing counsel and his client were trying to weaponize the court to further alienate me from my own children. On May 29th, and thanks to GoFundMe donations, I finally paid off my balance to the therapist. Her office told me that to resume services, I would have to complete a new intake packet and pay a new $600 deposit. I had enough money for the deposit in one session. The session would not include seeing my children because the new reintake work needed to happen first. The first appointment the therapist offered was for Mom. On June 6th, the judge denied the motion for no contact, but he kept my visitation restricted to reunification therapy sessions. He left all the contempt charges to be decided at trial. Then opposing counsel filed a third application for indirect contempt, citing the May 1 letter and unpaid spousal support, and the court reserved that for trial too. The court's minute order ended with 8 words. All remaining issues are to be reserved for trial. I sent the kids a group text. I love you so much. The trial was 11 weeks away, and I was very hopeful because I anticipated receiving soon a report from a clinical psychologist who reviewed the case and planned to testify at the trial.